Constitutional provisions. The rights of the accused are the right to fair trial, due process, to seek redress or a legal remedy, and the rights of participation in civil society and politics, such as freedom of association, the right to assemble, the right to petition, the right to self-defense, and the right to vote. In many countries with a democratic system and the rule of law, criminal procedure puts the burden of proof on the prosecution, that is. It is up to the prosecution to prove that the defendant is guilty beyond any reasonable doubt, as opposed to having the defendant prove that he or she is innocent. Any doubt is resolved in favor of the defendant. Civil and political rights. Civil and political rights are a class of rights based upon birthright into polity or designation otherwise of human rights. They ensure citizens' ability to fully participate in the civil and political life of the state without discrimination or political repression, and protect the freedom of classes of persons and of individuals from unwarranted infringement into those rights of governments, private organizations, and other entities. First-generation rights. First-generation rights, often called blue rights, deal essentially with liberty and participation in political life. They are fundamental, civil, and political in nature, as well as strongly individualistic. They serve negatively to protect the individual from excesses of the state. First-generation rights include, among other things, freedom of speech, the right to fair trial, freedom of religion, and voting rights. The idea of three levels of human rights dates to 1979 and is primarily used in European law. The term is rarely, if ever, used in the US. Criminal procedure. The legal process for adjudicating claims that someone has violated criminal law. Criminal procedure is a branch of constitutional law concerned with the rules of law governing the procedures by which authorities investigate, prosecute, and adjudicate crimes. Two provisions of the Constitution apply specifically to balancing police powers and citizen rights: the Fourth Amendment and the Fifth Amendment.
I'm going to start off by reading the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable speeches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath and affirmation, and particularly describing the place to be searched and the persons or things to be seized. Mapp v. Ohio, 1961, law enforcement officers forced their entry into Mapp's home without the proper search warrant paperwork. No evidence was found to what they were looking for. However, there were obscene pictures found. Mapp was arrested and convicted for possession. The U.S. Supreme Court ruled that evidence seized unlawfully without a search warrant could not be used in criminal prosecution in state courts. In Brady v. Maryland, 1963, defense had asked for statements of the other individual involved. However, not all statements were shown. They were not shown the one statement where the other individual admitted to the crime. The U.S. Supreme Court ruled that the prosecution must turn over all the exculpatory evidence to the defendant, which is known as the Brady Rule. This defines the duty of the prosecution and police to disclose any evidence that would tend to show the innocence of an accused. This is referred to as exculpatory evidence. In Gideon v. Wainwright, 1963, Gideon was charged with a felony and requested an attorney, and was refused counsel. The refusal of counsel was not a violation of the due process clause of the 14th Amendment, which states, "No state shall deny to any person within its jurisdiction the equal protection of the laws." In Escobedo versus Illinois 1964, Escobedo was denied speaking to counsel during interrogation. The U.S. Supreme Court ruled that criminal suspects have a right to counsel during police interrogations under the Sixth Amendment. In the Miranda versus Arizona in 1966, Miranda was not notified of his Fifth Amendment rights, protection against self-incrimination, or Sixth Amendment rights, right to an attorney. The U.S. Supreme Court ruled in favor of a warning known as the Miranda warning. Miranda warning: you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer and have him present with you while you are being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning. If you wish, you can decide at any time to exercise these rights and not answer any questions or make any statements. Versus United States in 1967, the U.S. Supreme Court ruled that recordings and wiretapping should be covered in the Fourth Amendment. Therefore, they expanded the Fourth Amendment protection against unreasonable searches and seizures also cover electronic wiretaps. The court redefined what constitutes as searches and seizures. It expands Fourth Amendment protection against search and seizures to also include what a person seeks to preserve as private and even in an area accessible to the public. In Terry versus Ohio in 1968, the United States Supreme Court ruled that under the Fourth Amendment, a police officer may stop a suspect on the street and risk him or her without probable cause to arrest. If the officer has a reasonable suspicion that they are, will, or are about to commit a crime. Terry stopped. Reasonable suspicion that a criminal activity is afoot. Brief investigatory detention, stopped and asked questions. Terry pat down. Reasonable belief a person is armed. Pat down outer clothing for weapons only. Arrest. Probable cause to arrest. Full search of the persons and the area within his immediate control. In New Jersey versus DLO, 1984 to 1985. The U.S. Supreme Court ruled that under the circumstances, the search of the student's purse was not a violation under the Fourth Amendment, and that it also applies to school officials since public school officials act as agents of the states. The High Court said school administrators don't need to have a search warrant or probable cause before conducting a search because students have a reduced expectation of privacy when in school. The Fourth Amendment's protection against random searches depends in part on your expectation of privacy. This expectation is less at school than at home.
Hello, my name is Adrian, and I'm going to be elaborating on some of the orders that were made by legislation regarding rights of the accused. The first one is Miranda rights. As stated before, this became a thing in Miranda v. Arizona. The Miranda warning was made in order to inform the accused of rights that they have while being in custody before being questioned. And on a federal level, this Miranda warning is pretty standard. It never really changes. But on the state level, there are certain variations depending on the state. In states that border Mexico like Arizona, California, New Mexico, and Texas, they require an extra warning to non-citizens that says if you're not a U.S. citizen, you may need to contact your country's consulate before any sort of questioning. And the second variation is confirmation requirements. This means that some states require the suspect to actually confirm whether or not they understood the rights that were just explained to them. If the suspect answers no to the first attempt, the officers then have to reiterate the Miranda rights to that person, and if they say no on the second attempt, those rights are now invoked, and the police cannot interrogate them until their rights are lawfully waived. There's also another variation that only exists in Virginia, and that requires the suspects to be warned that they can stop the interview at any time and exercise their Miranda rights. An individual cannot be questioned without hearing these rights, and if they are questioned before hearing them, everything that they say cannot be used in court as evidence, and if an individual decides to be silent after the Miranda warnings have been read to them, that silence cannot be used in court to incriminate them. The second right is the right to an attorney. This became a thing in Miranda versus Arizona, and is also stated in the Sixth Amendment that gives the accused the right to have an attorney present. This right can be exercised from the beginning of being arrested all the way to trial, and maybe even after. The attorney plays a huge role in a criminal case, as they do things such as help the defendant understand their rights and explain them what is going to happen as the process continues. They also uphold the rights of the client and make sure that they aren't being violated by law enforcement or in the courtroom. It is the responsibility of the attorney to negotiate a plea bargain with the government on behalf of the defendant. This right exists in order to help the accused to better understand what their rights are and have a fair shot at defending themselves, as well as to better understand the legal process behind everything that is occurring to them. The third right is the right to a speedy trial. This is stated under the Sixth Amendment, and it gives the people the right to request a speedy trial if they desire. There would be a couple of reasons for this request. If someone doesn't want the trial to take forever, or perhaps the potential harm to the defendant's ability to defend themselves, and also as to not cause any anxiety in the community and reduce any suspicion that may fall upon the defendant as they are awaiting trial. In a speedy trial, the rights of the defendant are to be upheld, and if those rights are violated, will result in the defendant's dismissal as well as the charges. The state can choose to offer the defendant more rights in a speedy trial than required, but they can't reduce their rights. When validating if a constitutional speedy trial occurred, things like the length of delay, which is the amount of time that passed between the start of prosecution and the trial date, the reasons for that delay, and if the defendant demanded for a speedy trial, which means they check if there was a speedy trial demanded, and when he requested for it. If he didn't request for one, then they dismiss the trial. If he requested for a speedy trial, then they assess if his rights are violated or not. And the last thing is prejudice to the defense. A speedy trial rights are one of the constitutional rights that can be waived. In some cases, when a speedy trial is being scheduled, the defendant feels that there's not enough time to prepare for the trial. They have the right to waive that trial in order to have more time to prepare for it. But if a defendant demanded a speedy trial and did not waive that right, they cannot claim that they did not have enough time to prepare for it. In another sense, if a defendant claims a speedy trial and a prosecutor is not prepared for it, there is a possibility that the charges might be dismissed. The last right is search and seizure rights, as stated under the Fourth Amendment. People have the right to secure their possessions, such as homes and vehicles. The only way an officer can conduct a search is under probable cause. They must have a search warrant in order to conduct a search on a home or vehicle. And search warrants must be signed off by a judge in order for it to actually be valid. Once they have that warrant, they can enter the location and search for the items listed on the warrant. On some occasions, the warrant can be extended to search beyond specifications if they see something obvious in plain view. There are exceptions to how an officer can go about searching and seizing for certain items and under certain situations. One of them being that a police officer can conduct a search without a warrant if they have the consent of a person to do it. But there are things that they can't do. They don't have a search warrant or the consent to search. Everything found will not be able to be used in court as evidence, and they cannot search without reasonable suspicion.